today. The first case is case number C2000011, Marcus Fontain versus Harjinder Sandhu. If counsel can please identify yourselves and your readiness to proceed.
Ma'am, my name is Marcus Fontain. I'm the plaintiff in the case.
Okay, good morning, Mr. Fontain.
Good morning.
Well, good morning, Your Honors. I'm Brian O'Connell. I'm representing H&R Cincy Properties, Harjinder Sandhu, Jasreen Sandhu, and in a first, also representing myself.
Okay.
Morning, Your Honor. Zach Prendergast. I am counsel for defendants Appellee's Prodigy Properties, LLC, Jeffrey Lane, April Lane, and myself.
Okay. And how are you gentlemen going to be splitting time?
Mr. Prendergast and I have discussed that. I will go first. I will use 10 minutes, and then Mr. Prendergast will be back and clean up in the last 5.
All right. Thank you very much.
And Your Honor, I would like to have 10 minutes and reserve 5 for rebuttal.
Okay, that was my next question. You took the words right out of my mouth. All right, so Mr. Fontaine, so you've got 10 minutes, and then the attorneys, they will be making their arguments, and then you will have your 5 minutes in which you can respond to anything that was raised at that time. Okay.
Thank you, Your Honor.
You can start whenever, we can start whenever you're ready.
Thank you. If I may, I would like to read some notes that I have made regarding the case so that we can keep the dates in the proper perspective.
That whatever you would like to do, we are fine with.
Thank you. So I'm just going to read from what I wrote. This is a breach of contract case stemming from the dismissed case, H.R. Cincy Properties, case number A170564, and the resulting damages from the breach. This case is intrinsically, or this appeal is intrinsically connected to that case. In fact, that case should have been consolidated with this one, but somehow it didn't happen despite the motions that were filed. When I refer to Mr. O'Connell, I am including his co-defendants, his clients, and the same thing when I refer to Mr. Pendergrast, I'm referring to his clients, which are also his co-defendants. On April 3, 2019, I filed my second amended complaint in this case, subject to this appeal. The events complained in my lawsuit relate to matters that happened in that case, in the H.R. Cincy case, in the other court, after February 11, 2019, when the receivership was supposed to be ended. The dismissal of the plaintiff lawsuit in this case was strictly based on matters related to that other case in the court of Judge Nestor, where the plaintiffs, post-dismissal of that case or post-dismissal of this plaintiff, created a receivership action commencing sometime in January of 2019, about a month before the receivership was to be ended.
Well, it was an extension of the receivership. Is that correct?
The extension of the extension of the receivership was an improper extension because Judge Nestor, the newly newly elected judge, did not have jurisdiction to entertain anything post-dismissal. We were dismissed on September 26, 2018 with prejudice. So anything that happened after the February 11, 2019, Judge Nestor conducted without jurisdiction. As a matter of fact, this court on February 26, 2021, on appeal number C190574, dismissed that case, dismissed the judgment that Judge Nestor issued against the dismissed defendant, including myself, on the grounds that the court did not have jurisdiction over the dismissed defendants to enter any judgments.
There was still a defendant left in the case, though, and I don't think this court ruled that. There was one defendant that was remaining. You were dismissed,
Right. The
There was
defendant.
there was still a case pending before Judge Nestor.
No, ma'am. Let me explain because I have watched the oral argument. The reason why Sinvexco in that case remained a defendant is because defendant O'Connell did not officially dismiss the defendant. In the settlement agreement that was entered on August 21, 2018, Sinvexco was supposed to be dismissed on February 11, 2019 by defendant O'Connell. He did not do that precisely because he wanted to continue the case. The settlement agreement is on file in this court on the docket TD 119. And if I may, I would like to continue with some of the dates. On October 31, 2017, H.R. Cincy and Harjinder Sandhu sued the plaintiff and others. On August 10, Judge Martin ordered the appointment of a receiver. That will be TD 145, I should say. On August 21, 2018, the parties executed a settlement agreement where the receiver agreed to end the receivership on February 11, 2019 in exchange for $11,000, which is a legally binding contract and a binding promise. This is the settlement agreement, TD 119. In this settlement agreement specifically says at 5 that defendant O'Connell on February 11, 2019 to end the receivership and enter the final entry of dismissal, he was supposed to dismiss Sinvexco. Instead, because they wanted to continue the receivership, he did not dismiss Sinvexco so that it could be used as an excuse to continue the receivership. But that didn't matter anyway, because Judge Nestor did not have subject matter jurisdiction or in personam jurisdiction, as you already ruled. On February 26, you already ruled that Judge Nestor did not have in personam jurisdiction over any of the dismissed defendants. Sinvexco it's just another. The fact that defendant O'Connell did not dismiss Sinvexco doesn't mean that it was not part of the contract. And let me say this, I was not involved in those proceedings in the beginning because I was completely shut out of the case. Judge Nestor on February 7 at a hearing even threatened me to incarcerate me if I attempted to appear pro se in the case. So I had no way of defending this. So this is my first chance to really defend the case. So on August 21, we entered into the settlement agreement. The receiver agreed to accept $11,000 for the receivership, for 6 months receivership from August 10 through February 11, 2019. Subsequent to that, on September 20, the payment to the receiver was made for $11,000 by the defendant's counsel. On September 26, defendant O'Connell executed at page 2 of the agreed entry of dismissal, TD 118. This is his signature on the back of that, on the second page. He executed the agreed entry of dismissal.
Mr. Fontain, just to let you know, your camera is off, so it's.
I'm sorry. Was it off all the time?
It was off all the time.
I'm sorry.
People appear off, so to me, it wasn't anything unusual.
Oh, no, not at all, not at all. On the same day that defendant O'Connell executed the agreed entry of dismissal, Judge Martin issued the final judgment dismissing the dismissed defendants, including the plaintiff. And if you read the final entry of dismissal, it specifically says that on February 11, the receivership was to end and everything was to be terminated, including the dismissal of Sinvexco. But I could not force Mr. O'Connell to dismiss Sinvexco. I mean, no one could. And the attorneys that we had at the time, Lord have mercy, they're the best money a poor attorney can buy, or vice versa. Post-dismissal of the plaintiff in the H.R. Cincy case, commencing January 11, 2019, in the court of the newly elected judge, Terry Nestor, they began a receivership action against the plaintiff and the dismissed defendants. only that we were not allowed to argue in that receivership action. We were completely thrown out of the courtroom. We were not to participate in such receivership action,
Well,
right?
They continued the receivership, and you were a dismissed party with no standing, and so that's why you weren't allowed to participate.
That is correct. It's exactly correct. So they continued a receivership action against the dismissed defendants, which were not present in the courtroom, right? In a court that did not have jurisdiction over the case to begin with. In fact, the Hamilton County Court of Common Pleas lost jurisdiction over the entire case the day that Judge Martin entered the final judgment of dismissal. That was the end of that case, right? So the acts taken
So
in the court of Judge
are you
Nestor.
saying that the court didn't have authority to enforce that particular order?
Oh, yes, Your Honor. Good point. Good point. The only power Judge Nestor had was to enforce the final judgment. He did not have any power to enforce the settlement agreement because the settlement agreement was not incorporated into the final entry of dismissal. And that was discussed at the oral argument in the H.R. Cincy case on January 19, 2021. This was thoroughly discussed at that time. Judge Nestor did not have the judicial power to entertain the settlement agreement because it was not included in the final judgment entry, right? So
But
what
he
happened here?
He did have power on the receivership, though.
If the final judgment entry divested the court, the Hamilton County Court of Common Pleas over the case, Judge Nestor did not have power over any receivership.
If we agree with you that that entry divested the court of jurisdiction, then maybe. But if it did not divest the court of jurisdiction, then he did have power over the receivership.
The receivership was ordered right here. The receivership was ordered by Judge Martin to end February 11, 2019. Judge Nestor did not have jurisdiction to entertain any receivership, but be that as it may, I was a dismissed defendant and they continued a receivership.
I'm just letting you know that you have an hour left, a minute left.
Okay, let me make it quick. So they fabricated a receivership action, and that receivership action is thrown out everywhere all the time. In the receivership action, Judge Nestor issued a judgment against the plaintiff for $79,000, right? Which is TD 135, by the way. All of that was in breach of contract. We had a contract that said that you were dismissing me from the case, the plaintiff, that you were not going to bother me anymore, the plaintiff, that you were not going to come after me, the plaintiff. That's a contract. And contracts are enforceable. One more point. Defendant Pendergrass will come here and say, oh, but I was a receiver. I was representing the receiver. I didn't sign the contract. Wait, they collected the money. The receiver collected the money. He represented the receiver during the negotiations of the settlement agreement. They collected the $11,000. So he cannot come and say, oh, there was no contract. In Ohio, an oral contract is an enforceable contract. So basically what happened is that
So
here,
Mr.
this
Fontaine,
case.
I'm going to go ahead and reserve your 5 minutes, okay?
Thank you.
Thank you. Counsel?
Thank you, Your Honors. It's hard to know where to begin, but let me begin with this. The fact that a litigant doesn't like the result reached or the judgment entered in one lawsuit does not afford the litigant the right to initiate a separate common pleas action in an effort to change the result reached in the first case. The proper remedy.
Ultimately, his
is the
argument
Court
is
of
that there was a
Appeals.
lack of jurisdiction. So he's doing a collateral attack based on lack of jurisdiction. How would you respond to that?
Your Honor, there was in fact jurisdiction over Mr. Fontain. That exception is very limited. The case law is very clear that collateral attacks are disfavored and should be looked at very narrowly. They will be permitted where the defendant or the plaintiff in the subsequent action is has not been served, and the court never had jurisdiction. In fact, every case you'll see that exception applied will be where the court never had jurisdiction over that party. The phrase that the courts use is to refer to the person as a stranger to the lawsuit. Your Honors, you cannot conclude that Mr. Fontain was a stranger to this lawsuit. He was represented by counsel. He was served. He was represented by counsel. He appeared in the action. In fact, even after he was dismissed, according to him, in September of 2018, between that point and February of 2019, Mr. Fontain filed no fewer than 25 pleadings in the case. Moreover, as this court knows, he appealed this. He appeared via counsel in the action, briefed issues after February 11th, appeared in the action. When the judgment was entered, he appealed it to this court. And now the court has remanded the case back to the trial court for recalculation of damages. So at this point, he is evidently, once again, a party to and subject to the court's jurisdiction in that case. All of this underscores what Mr. Fontain is trying to do here, which is to create lawsuits about lawsuits. His remedy was in the Court of Appeals. He exercised that, and it should not be permitted that a person simultaneously undertakes a collateral attack in a lawsuit and a direct attack through an appeal. Collateral attack is reserved for situations where there is no opportunity to undertake the direct attack, such as where the person was never served and never had jurisdiction. The court never had jurisdiction over that. One other point I did want to make is,
well, before you go there, the other
Yes.
argument that he makes is that the February 11, 2019 order, that at that point that divested the court of doing anything further with regard to the defendants.
Well, it's actually a little confusing for me to understand that, in the sense that his counsel continued to represent him in that action after that time, and he has subsequently appealed for the action since that time. If he had an issue with what happened after that date, he had every opportunity to raise that on appeal, and he has. In fact, he raised the issue on appeal, and the court has remanded on that basis. So,
To be clear, the only thing that he raised and was remanded was the issue of saddling him with court costs for the receivership after February 11th. It wasn't about damages. It wasn't about. He tried to file motions and was not allowed because he had been dismissed, right? So, court costs was the only issue in front of this court.
well, it was the only issue that he raised, and that's to my point, that if he had other issues, it was incumbent on him to raise them, or they were waived. And in fact, he did, if you look at the docket from that case, his counsel did in fact continue to file on his behalf after that point, including filings on the allocation of the fees. That was briefed on his behalf by his counsel after February 11th.
Now, he also argues that the court didn't have authority to enforce the settlement agreement because the settlement agreement was not part of the order, was not written into the order. How would you address that?
Well, the fact of the matter is that I argued that the court in the prior case, I argued that the court did have that jurisdiction because the parties agreed to that. And there is authority, the fact that where parties, by virtue of a party's actions, a party can again submit themselves to personal jurisdiction in front of the court. But the fact of the matter is that if that were in fact what the issue that he had every opportunity to file a motion to intervene in the case in order to re-interject himself into that and enforce the settlement agreement. One item I did want to mention to the court is that since the briefs were filed in this case, Mr. Fontain has filed yet another collateral attack on this case,
Well,
on the
that's not
receivership
part of our
action.
record.
It's not, but I think it's worth mentioning. And the other cases he's filed.
I understand, but it's
mentioned.
not part of our record and we should not even be considering that.
All right. Well, be that as it may, I think there is, it goes to the fundamental problem here of allowing these collateral attacks, especially ones that are brought not only against parties to a lawsuit, but against their counsel.
Can I ask a question? So
Sure.
my understanding is that there was one defendant that was left, and every other defendant was dismissed. So we have, was it Convexio or
Sinvexco.
Sinvexco? So do you believe that the defendants that were dismissed, like Mr. Fontain, should have been able to argue against the extension of the receivership, even though they were dismissed? Because the judge wasn't, he said, you're dismissed, you don't have standing. And of course, that was not appealed. You're right, that was not appealed to this court. Do you believe that those dismissed defendants did have standing to argue against the extension of the receivership?
I believe, yes, they could have. And the right mechanism would have been to intervene in order to do that. Let me just make a couple other points about the other issues that had been raised by Mr. Fontain in the case. One is that the court impermissibly converted the motion to dismiss to a motion for summary judgment. I think it's clear that that did not happen. Judge Cooper ruled on it as a motion to dismiss. And even if she had chosen to rule on it as motion for summary judgment because we filed in the alternative, that was permissible and no notice was necessary. He also raised the issue of Judge Cooper relying upon pleadings in other cases. Mr. Fontain cites some 4th District Court of Appeals cases from the 1990s for the proposition that on a motion to dismiss, court cannot take judicial notice of pleadings in other cases. That case law is simply outdated. The more modern trend with the advent of the internet, and this is supported by both the 1st District Court of Appeals and the Ohio Supreme Court, is that the court can take judicial notice of filings in other cases, as Judge Cooper did here. The other issue that he raises is that the Judge Cooper failed to rule on several motions and failed to grant an extension of time or hold hearings. Response to that is twofold. First, that any motion not ruled upon is considered to be denied, and the decision to grant an extension or hearing is within the court's discretion. I'm told I have just about a minute left, and I wanted to make one final comment to the court about some of the less than generous comments that Mr. Fontain has made about me in the filings in this case. Just to give you a few examples, he said defendants O'Connell and Prendergast, who have an uncanny ability to con a judge and to corrupt any judge willing to play their games, that defendants Prendergast and O'Connell represent a clear and present danger to the public. They are true definitions of a menace to society, and that they lie like most people breathe. The reason I mention all of that is, and I can, I've been doing this long enough. I can take it. As defamatory as that is, after a while you learn to roll with it. But what I think needs to be addressed here is the bigger concern about the precedent that would be set if this dismissal is not affirmed. It would set a dangerous precedent where, again, and this was, I think, apparent from the oral argument from Mr. Fontain. He wants to have a lawsuit about lawsuits and about what the counsel did and what the judge did. Because bear in mind, everything that he bases his claim on isn't just unilateral actions.
Aren't we just ultimately
parties.
bound to whether it's a proper collateral attack or not?
Yes, that is correct. And as I pointed out, the fact is that every case that has found the jurisdictional exception has been based on either a complete lack of subject matter jurisdiction or a complete lack of personal jurisdiction over the person. Every one of those cases involve situations where the court never had jurisdiction over the defendant, where the defendant was in fact a stranger to the action, where he was not served. Again, it cannot be said that Mr. Fontain was a stranger to this action. He did not have it. He had his day in court, and he had his opportunity to take that issue to the Court of Appeals, which he did. Given that this is a classic example of a collateral attack, the underlying public policy is just too important here to be ignored. We would ask that the court affirm the dismissal of the complaint filed by Mr. Fontain.
Thank you, Attorney O'Connell. Attorney Prendergast?
Good morning, may it please the court.
Good morning.
Just to quickly clear up a sort of a factual or sort of a false factual allegation here. Mr. Fontain references this settlement agreement and alleges us of being a party to it, of negotiating it. The receiver and no party of the receiver had anything to do with this settlement agreement. We are not a party to any settlement agreement. We did not participate in negotiating any settlement agreement. There is no evidence in the record to the contrary. You will not see a signature of any one of us on that settlement agreement. It has nothing to do with us. My client was a court-appointed receiver. We were appointed pursuant to orders entered by Judge Martin and then entered again by Judge Nestor. And that really goes to the heart of the matter that was the grounds for our dismissal here, is that in the state of Ohio, the law is clear that one cannot file a lawsuit against a court-appointed receiver without obtaining leave of the appointing court. And pretty much what happened here is that Mr. Fontain has an axe to grind about orders that were entered by Judge Martin and entered again by Judge Nestor, and he's decided to take that venue in front of Judge Cooper instead of litigating it back in front of the originating court here. And I have cited the case law in this. I think this is pretty clear. The reasons for these protections are very clear. There's really no issue. I know he makes some hay in his reply brief about, these are issues that were outside the brief. He attached all of these receivership filings and pleadings to his complaint, the order appointing receiver, the order extending the receiver, even to his brief, he even attached the September 12th, 2019 order in which Judge Nestor basically said the receiver did everything it was supposed to do. The receiver is completely exonerated. All the receiver's expenditures, actions, were completely approved, and he appealed that.
Was that determination of fact challenged on direct appeal?
I'm sorry?
Was that determination of fact challenged on direct appeal?
Yeah, he did have counsel that appealed that termination, and they appealed it on the very
Let me
limited.
clarify my question. The determination that the receiver had acted in good faith?
No, actually, that issue was not appealed. The only issue that was appealed was the allocation of the receiver's fees and costs. And this court has already passed on that. They remanded it to Judge Shanahan to recalculate those costs. And Judge Shanahan is going to hear oral arguments on that next week. That was the only issue that was appealed from the order. So right now there is an order on that's unchallenged that said the receiver in this case did every single thing that it was supposed to do. However, Mr. Fontain wants to relitigate that in front of this court, in addition to the federal district court, in addition to the Warren County Court of Common Pleas, in addition to the municipal court, all these other places where he's filed lawsuits against us. And really, this is, I'd say, as somebody who represents receivers on a regular basis, this is a textbook case of why this protection exists. Because essentially a receiver is appointed by the court. He's a servant of the court. He does everything at the direction of the court. However, he becomes a lightning rod for litigants with axes to grind who decide that they want to harass and basically use the machinery of the judicial system to settle scores. And in this case is particularly egregious because not only did he sue the principal of the company and his counsel, he sued my client's wife. Now, I mean, I don't want to get emotional in this hearing here, but I mean, how this could possibly be allowable without even going through the simple gatekeeping function that is set up by Ohio case law. It just can't be allowed, because that, to me, that sends a message to anybody who's willing to act as a receiver or a special master or a private selling officer, anybody who's willing to serve the court in a statutory capacity, that you can do this, but the court's not going to protect you if somebody decides to file half a dozen frivolous lawsuits against you and tie you up in court for the next 2 years. So the case law is really clear. And I think the court's choice here is really clear that, Judge Cooper decided to dismiss this case because Mr. Fontain didn't even go through the simple requirement of asking the leave of court that's required by Ohio law. So I would just ask that the court, affirm Judge Cooper's decision to dismiss this. If he wants to go back to Judge Shanahan and ask her for permission to sue us, he can do that. He can absolutely do that, but he has not done so in this case. So Judge Cooper was absolutely right to dismiss this. And I just ask this court to uphold it. Thank you.
Thank you. Mr. Fontaine, you have your 5 minutes.
Thank you. That dissertation that they both made is absolutely fraudulent. And let me say why. In the settlement agreement, I paid them, the defendants, $35,000 to stop the receivership on February 11, 2019, of which $11,000 went to the receiver. Of course, the receiver's signature is not on the agreement because the receivership is an ancillary to the case in chief. What they did after February 11, after Judge Martin ordered the receivership to end on February 11, what they did is they fabricated a receivership action in the court of Judge Nestor. So everything that they're talking about is a fabrication in the court of Judge Nestor. Now, Judge Nestor did not have the power to enforce the settlement agreement, and Judge Nestor did not have the judicial power or constitutional ability or whatever it may be to overwrite the final order, judgment order of Judge Martin. What happened here is that they went to Judge Nestor after Judge Nestor became a new judge, and they went there and they said, Judge, let's just fabricate a receivership action and let's keep them out and let's get a judgment. Eventually, what happened is that we ended up with a judgment for $79,000 from the fake receivership action. Now, none of the things that happened after February 11 should have happened. It was a breach of contract. They made a contract. I'm suing them for breach of contract. I'm not suing them for anything else. And so that I can answer Mr. Pendergrass, in the settlement agreement, in this contract, I fired him effective February 11, 2019. He was fired. In the final judgment, Judge Martin fired Mr. Pendergrass effective, really, because they were working for the court. Judge Martin fired him effective February 11, 2019. So what they did is, in a roundabout way, they went to Judge Nestor, who did not have jurisdiction over any of the dismissed defendants, who did not have jurisdiction over the case, and where, because of the final judgment entry, the Hamilton County Court of Common Pleas did not have jurisdiction at all, zero jurisdiction. So here we have Judge Nestor did not have jurisdiction. The court did not have jurisdiction. Judge Nestor didn't have in personam jurisdiction. Judge Martin ordered the receivership to end on February 11. Judge Martin fired the receiver effective February 11. I fired the receiver effective February 11 after paying him $11,000. So what we have here is a case of breach of contract, and anything else that they're talking about is for another time. It has nothing to do with this case. All of this thing about the receivership that cannot be sued. Well, let me ask you this. After Judge Martin fired them, after Judge Martin fired the receiver, why did they go back to Judge Nestor in violation, in breach of the settlement agreement, and fabricated a receivership action? When this case began, it began as H.R. Cincy Properties versus Marcus Fontain. It didn't begin as receivership action versus Marcus Fontain. The receivership was appointed by Judge Martin on August 10, 2018. And Judge Martin said, ended February 11, 2019. It doesn't say maybe, it doesn't say perhaps. This is not an order that you can say, well, it's ambiguous. No, it's not. It says ended, right? The settlement agreement. This contract here says ended. Here is the money to end it. Go away, leave me alone. They didn't. Until today, and he talked about the lawsuit that we have pending in Warren County. You know what they did? They filed 4 fake certificates of judgment lien. Okay.
This is not before us.
I can appreciate that, but he mentioned it, by the way. What they have done is unconscionable. They have dragged me through the mud. And Defendant O'Connell talks about me calling him a con man or whatever. You know how many times they have called me a convicted felon? 71 times. They have called me a vexatious litigant more than 60 times. I am not neither a convicted felon nor a vexatious litigant. These
Mr.
people,
Fontaine, just to let you know, you have 1 minute, okay?
thank you. Going back to the case. This is a contract. They breached the contract. Whatever excuse they have, they breached the contract. This is a final judgment order by a judge, by the judge presiding at the time we made the contract. And the judge said, you end the receivership on February 11th, end the story, and you dismiss in Vexco. Now that you mention it, dismissed in Vexco. So anything else that happened after February 11, 2019 was breach of contract. Nothing to do with collateral attack, nothing to do with any of that. I am demanding breach of contract. And the damages as a result of the breach of contract, which are probably right now in excess of $1 million, excluding $100,000 in legal fees that they have made me spend fighting them, trying to stop them from continuing their malicious litigation against all of the dismissed defendants, including my family. So going back to this is a contract. I'm suing them for breach of contract, nothing else. And
Understood.
Pendergrass, thank you.
Understood. Okay, thank you, Mr. Fontaine. And thank you everyone for your arguments this morning. I know this is a very important case to everyone here. We will take the matter under submission and issue a timely decision. And Mr. Fontaine, if I can take a second to confirm your mailing address, okay? I have it as 9378 Mason Montgomery Road. Is that still it? Number
Yes, it is.
425, okay. 45040, okay. And if for some reason there's a change of address, just let us know. That way, anything that we send you'll be able to receive it at the proper address.
Thank you, Your Honor.
Okay, thank you all for your arguments again, and I wish everyone a wonderful afternoon.
Thank you, Judge.
Thank you, Your Honors.
Thank you.
Close that, they'll be here, yeah.